Good morning to all of you. Normally, when an employee retires, before retirement itself, he has to nominate somebody to take his pension. So, for the nominee only the pension will be given. But of course, the nominee should be a registered or a legal heir. If the nominee does not become a legal heir, it is very difficult. It happened in a case now Bombay Gujarat High Court. It happened in the limits of Gujarat High Court. Normally, as additional SP, I used to face this type of problems. One man will be having two wives, both of them come, they quarrel for the pension benefits. One is a legally wedded wife, second is the live-in relationship, things like that. But here, she is also a legally wedded wife, but under separate act. SAP is a Special Marriage Act. Now, let us go into the details. So, a Muslim's second wife, a Muslim man's second wife who is a Hindu, she cannot get claims under the pensionary benefits. This is what was held by Bombay High Court. So, while disposing the case of Deepa Rani Kalita, her name is Deepa Rani Kalita versus State of Assam and 5 others. Right? So, sorry, Assam High Court. Assam High Court has clearly stated that the condition precedent in Section 4 of the Special Marriage Act, which says that for performing the Special Marriage Act, one condition is that neither party should have a spouse living. Neither party, either wife or husband, should not have any living wife or living husband. That means should be divorced or should have died. So, the marriage, please remember here, the Muslim man, he has married the woman under Special Marriage Act 1954, I believe, if I am correct. Right. So, Section 4 does not save a second marriage contracted by a Muslim with a Hindu woman and it has become void. Now, the problem is this. So, the Hindu woman is the second wife of the so-called Muslim man who worked in a mandal office, and the problem is he died in an accident. He died in an accident on 18/7/2017. Right? So since he died, so the pensionary benefits and also death benefits they were claimed by his present second wife. So, and she has approached and filed a petition before the Deputy Commissioner Office of Kamrup. He is working under the Deputy Commissioner. But he could not sanction even though her name was mentioned as the nominee. Because the point is, legal point is taken. Of course, the first Muslim wife, she has raised the objection, stating that she was his legally wedded wife and there was no triple talaq or talaq, nothing was that sort what there. But this woman stated that the first wife, she eloped with somebody, she discarded him literally. Therefore, actually since there is nobody to feed him, she has married this second woman under the promise that she will get the pensionary benefits which she could not get now. So that is the beauty of law. Because if the petitioner was married as per Section 22 of the Muslim law principles, definitely there would have been some change once she is converted to Muslim religion, and definitely she would have got the pension benefits. But this marriage was performed under Special Marriage Act. Special Marriage Act means belonging to two different religions. Right? So, actually he died he was working so and so, special marriage. So, even though she said that first wife discarded the man and she eloped with somebody, but there is nothing on record to prove that she went away. And only thing is she could say that she had a live-in relationship with him, and as per the Special Marriage Act, she married the Muslim man. She is a Hindu and she married her. So by the time of marriage, a woman, his legally wedded wife was there and she was not given a divorce. So she is the competent person to take the benefits. Incidentally, this woman, she was blessed with that Muslim man, she was blessed with a son. Now the court has given a leverage, because even though he is a bastard, definitely he has got all the legal, even this minor has got every right in the pensionary benefits. So this will accrue. First wife estranged, okay. So since the child will become the legal heir, yes, he will have the share in the benefits. So good judgment. Normally we will be under the impression that since the first wife allowed, and since the nomination was given in this in her name, definitely the plaintiff, that is Deepamani Kalita, is empowered, or she is having the right to take the pension. But no, when once the objection is there, law says, so section 4 of the Special Marriage Act is not complied with. So therefore they cannot give the so-called pensionary benefits. Good judgment, read it. In the beginning I told by mistake Gujarat High Court, this is Assam High Court. Thank you very much.